land law plays an important role in our lives. It is as important as the roof above your head. The definition of land in the Law of Property Act 1925 includes a range of things. It includes buildings or part of buildings, and it could be divided horizontally, vertically, or in any other way. And since the definition starts with land includes, it implies that land may include things that are not even mentioned in its definition. The development of land law started as far back in 1066 during the Norman Conquest. Fast forward to the present, although the idea of land registration was not new in 1925, as there had been previous attempts to bring in such systems, it was the Land Registration Act 1925 which made it a compulsory nationwide system. Today, approximately 85% of the land in England and Wales are registered land. Registered land refers to land which the title is registered with the Land Registry, which guarantees titles to such land, and it is proven by a search of the register. The idea behind this system is that the title to all land should be registered, and that the register should reflect all of the estates and interests affecting the registered land. There are three main principles of registration of titles set out by the former Chief of Land Registrar, Theodore Ruoff. Firstly, the mirror principle, which states that the register should be a mirror of the estates and interests affecting the land. Secondly, the curtain principle, which states that the details of any trust affecting the land should be kept off the title. Thirdly, the insurance principle, where an indemnity is payable by the state if loss is caused by errors in the register. While the LRA 25 had served well for nearly 80 years, the registration of title is now governed by the Land Registration Act of 2002, which entirely replaced the LRA 25 on October 13, 2003. The new act preserves the register of titles and continues the basic scheme of 1925, but introduced substantial amendments to the way in which the system works.
Land law in England and Wales went through a significant reform by replacing the LRA 25 with LRA 02. A system of registration of title was set up in the LRA 25 on some areas of land. Under this system, ownership of land and any burdens on that land are officially documented and placed on public land register. However, this system is currently governed by the LRA 02 instead. Section 4 of the 02 Act outlines situations where first registration is compulsory, which includes when the freehold estate is transferred, when a lease for longer than 7 years is newly granted, and when the estate becomes subject to a first legal mortgage and the lender takes the title deeds. According to Gray and Gray, the objective of land registration is that any prospective purchaser of registered land should always be able to verify, by simple examination of the register, the exact nature of all interests existing in or over the land which he proposes to buy. This is rendered in LRA 02, where one of the main aims of the Act is to transform the land register into an entirely electronic registry system, which is known as the e-conveyancing, which could and should reflect the state of the title of the land at any given time accurately and completely. This ensures the quick, efficient, and inexpensive transfer of assets and interests in land, while making sure that third-party interests in land are properly protected. Furthermore, it also ensures that the investigation of the title to land would be possible, with minimum additional enquiries and inspections, which ultimately defines the mirror principle, where the idea that the register should reflect the totality of the rights and interests concerning land registration of title is encapsulated. Nonetheless, there are some interests in land which need not be registered, yet still bind any person who acquires an interest in land. These are called Overriding interest. Overriding interest in land registration bind both the registered owner and the person who subsequently acquires interest over the titled property. Schedule 1 under the LRA 02 grants short leases and overriding interest over first registration, whereby overriding interest on registered disposition are listed in Schedule 3 instead. These interests are sometimes called a crack in the mirror because the register does not reflect these binding rights. This contradicts a fundamental essence of the land registration system. Under the land charges system, it is stated that if a charge is registered incorrectly or not at all, it is at risk of being unenforceable, which contradicts overriding interests that are not registered yet still binding. These rights can create great problems of unfairness for potential purchasers as they may be bound by rights of which they are unaware of. The Law Commission and the Land Register consider overriding interest as a major obstacle. They were not completely eliminated from the O2 Act, possibly because they are too deeply entrenched in the law to be dispensed with. The LRA 02 reduces the number and effect of this. Unlike in the 25 Act, the consequence of an overriding interest depends on whether it tends to override a first registration of title or a disposition of a registered title. A principal example of overriding interest is the interest of a person in actual occupation, which will then be discussed by Bree later in this video. It is evident that the LRA 02 undermines the main purpose of the mirror principle because of the overriding interests that are not recorded by the land register, leaving the potential buyer with no option but to inspect and make inquiry regarding the property himself, as stated in Schedule 1 and Schedule 3 just now. This can burden the purchaser and leave no absolute certainty, which is the ideal of all registered systems throughout the world, to the level that absolute title becomes something of a misnomer.
Although the idea of a mirror may in theory be the perfect execution of land registration, but in reality it brings to light that indeed there are cracks which have shown the compromise of the principle's integrity. These have emerged primarily from the clear contradiction of overriding interest, as the mirror in such case fails to reflect to unregistered interests over land. Academics such as Dixon and Dworkin seem to disagree with the idealistic hope of a completely reflective register. Such cracks manifest because there are flaws in the mirror principle that prevents the land register from reflecting a complete picture of the title. An example of such flaw is overriding interests. Overriding interests are defined as those interests which bind the registered proprietor of registered land, even though he has no knowledge of them and no reference is made to them in the register. They are an obvious breach of the mirror principle of land registration because they make it impossible for the register to be a true reflection of all those interests in the land.
Section 29 of the LRA 02 gives priority to overriding interests, even though they are not included in the register. The categories of overriding interests are set out in Schedule 3 of the Act, which replaced the overriding interests which existed under Section 70 of the LRA 25. Overriding interests include leasehold estates in land, interests of persons in actual occupation, and easements, customary and public rights, local land charges, mines and minerals, and other miscellaneous interests. Perhaps the most important of overriding interests is that of someone that is in actual occupation. Actual occupation was mentioned in Para 2, Schedule 3 as an overriding interest. However, the phrase has not been statutorily defined. Nonetheless, according to the case of Williams and Glyn's Bank Limited and Boland, actual occupation is intended to be interpreted as it is written, so long as they are taken as ordinary words of plain English. That being said, Mallory Enterprise Limited and Cheshire Homes Limited held that actual is meant to be taken as apparent or patent, such that the fact of occupation would put a person inspecting the land on notice that there was some person in occupation. It can be seen that a person claiming actual occupation may successfully show such occupation, even if it is intermittent, so long as they are able to point to some physical evidence or symbol of their continued residence at the property, as well as evidence of their intention to return to the property. In Chohokar and Chohokar, previous occupation and an intention to return to the property with physical evidence such as furniture meant that the occupation sufficed. Lord Denning held in Caswell that fundamentally the purpose of protecting overriding interests by actual occupation is to protect the person from having his rights lost in the welter of registration. It should be noted that the LRA02 had already cut down the circumstances in which an overriding interest can be claimed on the basis of actual occupation. It did this in a number of different ways. These included removing protection from those who were merely in receipt of rent and profits of the land, as opposed to in actual occupation, and limiting the extent of the overriding interest to the land, of which the right holder was in actual occupation. On the other hand, interests which have, however, been held to be an overriding interest by virtue of their holders being in actual occupation include a beneficial interest under a trust of land, an option, an unpaid vendor's lien, and the right to seek equitable rectification of a document. As the rule of nemo dat and caveat emptor put the burden on the buyer to inspect carefully before purchasing property or goods, hence, the buyers have to carefully inspect the land and be aware of the occupants on the land, even though they might not have the equitable interest as opposed to the legal title, since they are protected under this right. However, the LRA02 does protect a purchaser, as there are two exceptions to an actual occupier's interest being overriding. The LRA02 excludes the interest of any actual occupier of whom inquiry was made before the disposition and who failed to disclose the right where he could reasonably have been expected to do so. This is seen in the case of Hollow Limited and Stockton Estates Limited, which shows that if they fail to reveal their interest upon inquiry from the disponeur, the occupier's failure to reveal the existence of their rights is fatal for any claim of overriding interest. The second exception is when the relevant occupation was neither reasonably discoverable nor was it actually known by the disponee. This places a restrictive understanding of what being in actual occupation means. An interest will not override if it would not have been obvious on a reasonably careful inspection of the land at the time of the disposition, except where the disponee of the land had actual knowledge of the occupier's interest at the time of the disposition.
Beyond these exceptions, it can be seen that the purchasers will be vulnerable if they fail to make further enquiries of the occupiers once it is seen that the position on the ground and the title deeds don't match up. This places too great of a burden on the purchasers to inquire regarding the property and great lengths before their purchase, effectively rendering the mirror principle irrelevant as the register does not reflect the full character of the land. Short leases under Schedule 1 of the LRA02 is granted an overriding interest over first registration if the term granted is not more than 7 years, subject to certain exceptions under Section 4, subsection D, E, and F. This is nevertheless an improvement over the previous LRA25, which granted overriding interest for 21-year leases. This dramatic reduction demonstrates how the LRA02 aims not only to bring a vast range of short-term leases onto the land register for the first time, but also in doing so, render them capable of electronic grant and disposition. Therefore, under first generation short-term will, legal lease will override. However, any existing lease that was an overriding interest within Section 70, subsection 1K of the 1925 Act immediately before the 2002 Act came into force preserved the overriding status under LRA 02. The use of the word granted in the 1925 Act was interpreted as restricting the category to legal leases, suggesting that equitable leases interpreted from the similar provisions of Section 70, subsection 1K LRA 25. However, the overriding status of leases despite LRA 02 can be problematic because even though the 21-year period lease has been reduced, commercial leases can be for 10 years or 15 years and would still not appear on the register. This causes lack of protection for the purchaser. Another overriding interest would be easements. Easements are the rights to use of another's land. However, it can be seen that the LRA 02 is leaning towards the side of the purchaser rather than the one benefited by the interest in the land. This is although legal easements are classed as overriding interests, equitable easements have to be recorded and notice given of them in the register, which protects against easement that arise by implication only. However, there still remains a requirement of an absence of knowledge of their existence from the one making the disposition and the inability to identify upon reasonable inspection. The issue of not having a reflective register comes to argument. This overriding interest puts the purchaser at great inconvenience to discover and take into account of these easements. The above three categories represent the most important overriding interests, with the actual occupation provisions being the widest in scope simply because it is possible that any proprietary right can attain overriding status if coupled with actual occupation. Nevertheless, there are other examples listed in the schedule in regards to overriding interest. Customary rights are expressly preserved in paragraph 4 and encompass rights that are enjoyed by all or some inhabitants of a particular area. Public rights also remain a category of overriding interest under the Act 2002 in paragraph 5 and means these rights are accessible by anyone including non-landowners simply by reason of general law. This also includes local land charges as specified in paragraph 6. These are not to be confused with land charges under LCA 72 but are instead rights within the local LCA 75 and relate to such matters planning highway and other local authority matters. In addition, rights in relation to mines and minerals may also override under paragraph 7, 8 and 9 of Schedule 1 of the LRA 75 Act. They include rights to coal and other mineral rights. It must be accepted that overriding interests in general represent a considerable departure from the fundamental principle that the register is a mirror of the title. The Law Commission therefore made perfect reflection a priority and it remained the fundamental objectives of the land registration system. In this report, the Law Commission strived to close the cavernous crack in the mirror. Overall, the LRA 2002 has reduced the power of overriding interest in both schedules to ensure that a potential purchaser is bound only by those unregistered interests which for practical reasons that the purchaser had a realistic opportunity of discovering the existence of the interest by a physical inspection of the land or by making normal inquiries of the transferor.
Previously, the LRA 25 failed to eliminate the cracks in the mirror and had instead preserved certain interests which may override registration. These overriding interests burden registered land by operating on a superior plane to other registrable interests, binding purchasers outright and disproportionately, empowering the overriding interest holder. The LRA 02 tries to draw a balance between the contrasting views by limiting the scope of overriding interests, particularly when they are not easily discovered. Consequently, an occupier's right will prevail over a purchaser's only if the latter has knowledge of occupation or if there was a careful inspection of the land. Then the occupation will be evident. It can be seen that the register will never be a perfect mirror as everything cannot be expected to be entered on a register. An example would be the overriding status of interest belonging to persons in actual occupation of the land and informally created rights where no property professional has been involved are unlikely ever to be registered by the parties, and short-term rights or rights fundamental to the good use of lands are either too transient or important to be subject to a registration requirement. Thus, the register can never truly reflect the full characteristics of the land. However, there is an undeniable improvement in LRA 02 by comparing it with the reflection of the mirror in LRA 25. Number of interests will be brought onto the register through operation of e-conveyancing when it is implemented, which is also one of the significant steps towards achieving the mirror principle. This is because the Law Commission foresees that the majority of interest in land will only be capable of being created when it is simultaneously registered. Such interests will therefore never be capable of being overriding, as they will rely upon registration for their protection and enforcement. These unregisterable rights, deemed so important that they do not require registration and which have to date been given statutory protection, undermines the concept of the mirror principle. The very fact that an individual has a right which cannot be discovered by inspecting the land register can create problems for a purchaser who, though prudent, has been misinformed by the vendor as to the presence of other persons on the property who may have acquired the third-party rights. The intention of LRA 02 was that the need for purchasers of land to make the additional title investigations should be kept to a minimum. Overriding interests are the exceptions to these principles. Nonetheless, Dixon suggests that an imperfect reflection does not in scope diminish the integrity of the register. The call for reform on overriding interest would prove unhelpful to the growth of land law, as the values of them far outweigh the issue. Although the existence of such large groups of rights which hold power against the purchaser's right over the land do indeed render e-conveyancing less reliable, Dixon stresses that registration of title is not intended to replace physical inspection of the land. Furthermore, the LRA 02 encourages purchasers to disclose any known overriding interest to the registrar in an attempt to protect their rights.
As discussed earlier in the video, there has been ongoing developments in the law to improve the protection of purchasers and any third parties. Nevertheless, due to the existence of things such as overriding interests, they often undermine the attempts made to improve the reflection of the land's character in the land registry, thus preventing the application of mirror principle in reality. This, in turn, reduces the protection intended to be provided for the purchaser and any other third parties. Furthermore, to enable an effective system of electronic dealing in land, the land register must be a complete and accurate reflection of the title state in the land at any given time. Without this, it will not be possible to investigate title online with an absolute minimum of additional inquiries or physical inspections of the property. Hence, in order to protect purchasers and any other third parties, the e-conveyancing system should be implemented as soon as possible in order to make the application of mirror principle a reality. In doing so, it will be impossible for any interest in registered land to be created except by means of registration. Moreover, since it will be difficult to create many interests without registering them, the number of overriding interests that can exist will necessarily diminish. The register will therefore become a much more accurate record of the title than it is at present. This accords with the fundamental objective of the LRA 02 to make the register as complete and accurate, and the record of the state title can be given at any time. Although LRA 02 is a good step forward, the mirror principles as it stands today is merely in theory and is flawed. However, it is hoped that with the development of the law and the future of e-conveyancing, the mirror principle will entrench itself as one of the hallmarks of the English land law to protect the rights of purchasers and third parties.